There's nothing funny about nearly 1 million lives.
You want answers?
I'm as mad as hell, and I'm not going to take this anymore.
You want answers?
You have offended my family.
I think I'm entitled. You want answers? I want the truth.
And you have offended a Shaolin temple.
You can't handle the truth.
Surely you can't be serious.
I am serious. And don't call me Shirley.
All right, two stories popped up today from the state of Michigan that remind me of the inevitable tragic absurdities we get by trying to separate patients from criminals. With scare quotes, criminals. Wrap your mind around these latest examples of legal bureaucracy facing sick people who just want to use marijuana under the Michigan Medical Marijuana Act. In Nashville, Michigan, there was this patient named Tony Allen Green. Tony had a valid patient registry card. Tony had less than 2.5 ounces of marijuana on him, as allowed by law. Tony had a friend named Al Thornton. Al was a patient who just applied for a valid patient registry card. However, under Michigan law, after 20 days, his application, along with his doctor's recommendation to use cannabis medically, becomes just as valid as a registry card. Tony, a legal patient, gave some of his marijuana, less than 2.5 ounces, to Al, a legal patient. Somehow, police became involved. They don't arrest Al, because he's just holding less than 2.5 ounces of marijuana, but they do arrest Tony for giving Al less than 2.5 ounces of marijuana. Now, isn't that silly? Tony can sit around puffing joint after joint of his 2.5 ounces. Al could sit right next to him and do the same thing. But if either of them pass a joint to the other, it's a crime? The Berry County Circuit Judge who saw this case agreed that it was silly. Section 4 of the Michigan Medical Marijuana Act clearly allows patients to have 2.5 ounces. They were both legal patients. So the judge dismissed the marijuana delivery charge against Tony. Prosecutors, however, appealed the dismissal. As they read Section 4, they could only find protection for Tony's and Al's possession of marijuana. They didn't see anything protecting the delivery of marijuana. The Court of Appeals, however, upheld the Berry County judge's dismissal, writing, quote, "The Michigan Medical Marijuana Act does not place any restrictions on the transfer or delivery of marijuana between adult patients, and we decline to read any such restriction into the act," end quote. Unfortunately for Tony, the Supreme Court of Michigan disagreed. They have now reinstated the delivery charges against Tony. The court is relying on its February decision in the case of Michigan v. McQueen, where they held, quote, "Immunity does not extend to a registered qualifying patient who transfers marijuana to another registered qualifying patient for the transferee's use because the transferor is not engaging in conduct related to marijuana for the purpose of relieving the transferor's own condition or symptoms," end quote. You got that? Tony can puff joints all day from his 2.5 ounces because that benefits him medically. But giving marijuana to Al does not benefit Tony medically, so that transfer's a crime. Although Al can then go ahead and puff the joints that Tony gave him because that benefits him medically and isn't a crime. Then there's the case of Benjamin Curtis Wahlberg. 4 years ago, police caught him growing 25 marijuana plants, so they say. He disputes that. Ben didn't have his medical marijuana card, so he was charged with possession and manufacture of marijuana, a felony that could put Ben behind bars for 7 years. Ben argued that he suffers from severe anxiety and insomnia, and he had a recommendation from his doctor for medical cannabis use. Michigan had just passed the Michigan Medical Marijuana Act a few months prior to Ben's arrest. That was enough for the Ottawa County Circuit Judge, Edward Post, to dismiss the charges against Ben. Prosecutors appealed that dismissal, arguing that despite Ben's recommendation, 25 plants was more than twice the 12-plant limit written into the Michigan Medical Marijuana Act. The Court of Appeals disagreed with the prosecutor that only 12 plants are allowed under the act. The court noted Section 8 of the Michigan Medical Marijuana Act, which provides an affirmative defense for a patient who is, quote, collectively in possession of a quantity of marijuana that was not more than was reasonably necessary to ensure the uninterrupted availability of marijuana for the purpose of treating or alleviating the patient's serious or debilitating medical condition, end quote. As the court noted, unfortunately, the legislature neglected to define the term reasonably necessary within the statute, leaving it open to interpretation based on the individual circumstances of each case. So, the Court of Appeals upheld the Ottawa judge? No. The court sent the case back to Ottawa County so the court could give their interpretation based on the individual facts of the case. Meanwhile, the Michigan Supreme Court has ruled on the cases of People v. Kolinek and People v. King, which clarified that a person must have their medical marijuana registry card or doctor's authorization before they possess or grow marijuana and must display their card or recommendation at the grow site to qualify for any medical defense. Therefore, Ben could still face the felony manufacture charge in Ottawa County. Thankfully, the Ottawa County prosecutor decided to cut Ben some slack since the law was so unclear just months after passage. He allowed Ben to plead guilty to misdemeanor possession with no jail or probation. So, yes, Ben has to check the "Have you ever been convicted of a drug-related crime?" on any employment application, and his shot at some government jobs and security clearances is gone, but at least he's not in prison. These are just two patients whose lives were turned upside down for the past 4 years while Michigan courts tried to make sense of their program to separate patients from criminals. Two patients who ended up being criminals anyway. Wouldn't it just be easier to legalize marijuana for all adult uses and stop trying to determine who's healthy enough or who didn't follow the rules properly in order to put them in a cage over pot? That story is available up on my blog at radicalruss.com. I've also forwarded it to Huffington Post's Detroit section. We'll see if it makes that. That's all the time we got here for Hour 1. Stay tuned for Toker Talk Radio here in Hour 2. We'll take your calls at 971-533-7111. Also be hanging out in the chat room with Brian the Red, who's holding down the fort there in Portland, Oregon. Remember, no new show tomorrow. I'll be in the air flying to the High Times Medical Cannabis Cup. Also, no show on Monday. I'll be on a train coming back home. But next week, all new shows from Portland, Oregon with me and Brian the Red and all the crew. Thanks for joining us. For Brian the Red, I'm Radical Russ. And until next time, take care of each other, tokers.